Okay, okay, no, let us continue without camera. Sorry for the trouble.
Right.
Sorry for the trouble.
Good.
Yeah.
Now, Mr. Tolley, you indicated when at the first of the day's hearing on this PTR that the claimant had objections to the admission of the expert report, which the defendant wishes to put in for the trial. I'd like to hear, please, from you on what those objections are.
Yes, my lord. May it please the court. My plan was to just address you very, very briefly on just a number of repeated failings by the defendant in relation to the filing of this report, and therefore I say is relevant to the permission sought. Then just to mention the backdrop of the rules of the DAFC in relation to Part 31 and what we say should be required of an expert report if it is to be admitted. And then just to briefly turn up the report and make a few submissions on why we say it doesn't meet the necessary rules. If I just start off very quickly then, the defendant in this case failed to comply with the disclosure process that was set out in the original case management order. And I just mention that because it sets up a pattern of behaviour, we say, on the part of the defendant to not pay any heed to the directions that were emanating from the registry. They then failed.
Sorry to interrupt. Was that a matter of delay, or has there been is there continuing a disclosure failure?
No, it was significant delay, but ultimately the documents were disclosed.
Yes. Thank you.
And likewise, and this relates to the ruling that was made at the first part of this hearing in relation to lay witness evidence, the defendant was directed to exchange witness statements on the 9th of December 2020 and failed to do so, and we then saw a late application for the same. And then the original date for the exchange of expert evidence was Wednesday the 13th of January 2021. Then we came to the CMC, as it were, and no application was made at that date, and the registrar directed, as you heard last time, the defendant to file an application. And as I said, and I looked at the email subsequent to the last hearing, a member of the registry team sent an email highlighting the Part 23 points to make an application following that CMC, and still no application was forthcoming. And ultimately, we were left with a short sentence or two naming the lay witness and the expert evidence that was to be provided. Again, all out of time. So our primary submission is that the defendants failed to comply with the rules repeatedly, and whether they're a litigant in person or not, and we say, given what was just stated about Mr. Koda's legal qualifications, they're potentially not. That they're simply out of time, and it wouldn't be in the interests of justice or orderly administration to permit this application.
Now, could I just want to get, so sorry, I just want to get the chronology absolutely right. There was a CMC order, I think, on the 3rd of September of last year.
Yes, I believe that's right.
And that ordered that the evidence was to be served by the 6th of September. Was that right? Or have I got that wrong?
The CMC order I have is dated the 6th of September.
Oh, I see. It was dated the 6th. And yes, that's my mistake. And what was the date given?
Are we talking about expert reports now?
No.
It was on 27th of January, sir. Your Lordship, need to see that we gave time until 27th of January to submit expert witness list. But, unfortunately...
Sorry, Mr. Koda, thank you very much. I just want to carry on with Mr. Tolley.
Yeah, sorry for the interruption.
I see. So there came a point when there was a deadline of the 27th of January of this year. Is that right?
Well, it depends. Sorry, my learned friend is jumping ahead slightly.
Yeah, let me read out. I will read out.
Mr. Koda, if we may speak, address the judge one at a time. I'll let you reply. Let me just explain what my understanding is.
Let me read out. Without interruption, Lordship. Without interruption, let me read out point number 12 of CM order.
Sorry, Mr. Koda, you're not with
sorry.
You're not complying with the usual conventions of how these applications go. I'm going to hear from Mr. Tolley without interruption, and you, of course, will have an opportunity to
Pardon,
reply
I beg your pardon.
in full to me. Now,
I beg your
Mr.
pardon.
Tolley, there was a direction that evidence be served by the 27th of January. Is that correct?
Well, my lord, I think we should just take it in stages. So, depending on how wide your definition of evidence is, the first date was in relation to witness statements,
Yes.
and they were due on the 9th of December.
On the 9th of December, so lay witness statements.
Yes, that's correct. And any evidence in reply 2 weeks later on the 23rd of December.
Yes. Yes.
And then turning to expert evidence,
Yes.
the first date was the 13th of January 2021 for the claimant. And then unusually, or perhaps not unusually, but it wasn't simultaneous exchange. It was then the defendant to file and serve its expert report 2 weeks thereafter on the 27th of January.
On the 27th of January. Thank you very much.
Yeah. And finally, my lord, just for completeness, there was a date for supplemental expert reports on the 10th of February.
Yes, I see. I see. Now, there was a PTR fix for the 17th of February.
Yes, my lord.
And was that the next time that the parties were before the court on the
Yes, my lord.
on the 17th of February? And at that stage, as I understand it, the defendant filed a witness list identifying a lay witness and the expert witness.
No, my lord, that's not my understanding. Well, I think on the 17th, when that initially went ahead, then nothing had formally been filed. But then there was indicated at that hearing that evidence, and then following that, and this is the chronology that I referred to on the last, the first part of this, there was then some emails exchanged towards the end of February and the very early part of March, where debating over the mode and method of the proper application. And the defendant in the end just filed a short Word document upon the e-registry, I think, but didn't make a formal part 23 application.
I see. I see. Yes. Well, then when did the matter get back before the registrar?
So immediately upon that, the claimant essentially complained, I suppose, and put in a response, which you will have seen.
I've seen it. It's an email to the.
And we're at great pains to say we don't think it is an application, and we shouldn't have to respond to it. But if it is, then we disagree, and we also reserve our rights to comment more fully.
Yes. Yes.
So that was the next point, and then following that, we had the pre-trial review last week, and you heard from us there.
But when did the registrar indicate that there had to be a Part 23 application for permission to serve late evidence, as far as the defendant was concerned?
Well, the claimant's case is that was, and I have a contemporaneous note, that was made extremely clear at the CMC. And then
well, which CMC? Do you mean the PTR or do you mean a CMC?
No, I mean the CMC.
Well, when was that held?
I think that's the 17th of February. I'm describing that as a CMC. It's given as a progress monitoring date, and it was on the 17th of February. I'm calling that a CMC separate to the PTR that we started last week. Yeah,
I understand. Yes, and it was then that it was indicated that nothing short of a Part 23 application would have to be made.
That's correct.
Yes, do go on. Sorry to interrupt.
No, that's absolutely fine. And then really, so I think the chronology is quite clear, and we're saying that it's not in the orderly administration of the case or the interest of justice to keep permitting these clear deadlines to be missed. And I've already made the point that there was direct guidance given as to how a formal application should be made, and none was forthcoming. So I won't belabor any of those points any further. And perhaps now is a good time to hear from Mr. Kodeth on those points before.
No, I don't want to do that. I want to hear now your detailed objections to the contents of the expert's report.
Happy to continue, my lord. So Before I turn to the content of the report, we've now received the report from Dr. Ahmed Ghali, and it's 10 pages in length, and it's headed an independent consultancy technical and contractual report.
Yes.
But I'll come on to the fact that the claimant has doubts about its independence. And it refers on its face to a DIFC LCIA arbitration when, of course, we're taking part in a set of court proceedings, but I don't think that's overly material, but it might give some indications to the expert's attention to detail that he's paying to this case. But the key point really is that the key rules are Rule 31 of the DIFC rules. And there at 31.3, we see that it's the duty of an expert to help the court on the matters within his expertise. And also, importantly, at 31.6, an expert should assist the court by providing objective, unbiased opinion on matters within his expertise. And we say, most importantly, should not assume the role of an advocate.
Yeah.
Now, I also mentioned 31.15, which says, because I'm not sure if this is any longer the case in the English court, but here in the DIFC, it says a party would usually apply for permission at the CMC, and where they do so, they must identify the field in which he wishes to rely on expert evidence, and where practical, the expert in that field on whose evidence he wishes to rely. Now, I don't think the application expressly states any field, and we say therefore is potentially deficient, but we do note the defendant described Dr. Ahmed Ghali as a consulting engineer, arbitration and engineering expert.
Yes.
So if that is his remit, it's interesting given there's no arbitration taking place, but also one would expect the contents of the report to be limited to comments on the behaviour of reasonably competent consulting engineers and engineers more generally. And not, and this comes back to my point at 31.6, to advocate for the party or to make legal submissions.
Yeah.
Further, the DIFC rules need to be read in conjunction with the protocol, which is the protocol for the instruction of experts to give evidence in civil claims.
Yes.
And they stress there's an overriding duty to help the court, at paragraph 4.2 I'm reading from, and this duty overrides any obligation to the person instructing or paying them. And experts must not serve the exclusive interests of those who retain them. And I'm going to come on now in a second just to take you to the report, just to show you examples where we say that hasn't been followed. So if I start with independence and we turn up the report.
Yes, I've got it.
I'm grateful. There's a statement of neutrality at paragraph 1.3 where Dr. Ghali says, we herein also confirm of no affiliation or business associations with either of the above disputing parties before, and we issue this report as a neutral party declaring our conclusions as per the rules, contract documents and norms under the applicable laws of UAE.
Yes.
That may go some of the way, but we say that's not a full statement of independence that one would ordinarily expect to see. And the reason we say that is because of the test for independence that's given in the rules and in the protocol, and we suggest that the content of this report betrays that alleged neutrality and/or independence, because Dr. Ghali acts as an advocate in his client's case. And to make that good, I wanted to just take you, my lord, to some of the paragraphs that we say are particularly unusual. So the first is paragraph paragraph 3. So if we scroll down to page 4.
Yes, I'm there. Yes.
Here, what's happening here is Dr. Ghali is setting out a extract from the contract headed duration of services,
yes,
where it says the obligation will terminate. And then underneath, rather than giving the usual evidence of an expert in consulting or engineering, he seems to be engaging in legal submission and passing judgment on things that either a lawyer might submit or a judge might rule in their experience of how the legal profession and UAE law operates. He says, as per the agreement, the claimant did not give with supporting documents any dates. And then he goes on to say, item 8.1.2 of the agreement, which is related to an event stating the particulars on the occurrence of that event, the claimant did not declare or identify clearly the duration of his services. And then in conclusion, he says, it is so clear the duration of services is likely to the completion of the related sum contracts and conditions of the contract. now it's quite garbled and hard to understand the English there, but my submission is that more of the nature of acting as an advocate, and is legal submission on the legal meaning of contractual clause 8.
Yes. Go on.
And a similar argument can be made at 4.1.1. If one scrolls slightly further to the bottom of the page onto the next page, there are yet more extracts taken from the pleadings, essentially. This is what these are, these highlighted clips there. And at the bottom in the final paragraph 4.1.1, he says, I find out that explanations and getting the client to understand and satisfaction are the consultant, the claimant responsibility. If the consultant, the claimant, states that the client, the respondent, didn't understand the scope of services, thus the consultant, the claimant, is in default. And again, we say that these interpretations of the arguments in the case and the alleged finding of default, it's not for Dr. Ghali to make those statements or findings. And finally, at 4.1.4, if one scrolls down to page 6, going on to 7, here Dr. Ghali goes so far as to set out relevant articles of the UAE civil transaction law and to cite Article 117 in relation to evidence. And he continues, and he essentially concludes at 4.1.5 his view of the meaning of UAE law. And again, we say that's not for an engineer to do, and therefore it taints the whole report, but at least this section shouldn't be admitted. So I think that's the substantive content, but then there's a few further comments I just wanted to make about the form, as it were. One would ordinarily expect a document like this to contain a statement of truth, and in fact that's required under Rule 31.56, and it normally, I won't read it out fully, but the confirmation is in a usual form, that the facts stated therein are within the expert's own knowledge and made clear where they believe them to be true, etc. There's no such statement of truth in this document, and we say that's another significant failing. And there's also no statement that the expert understands his duty to the court, has complied with it, and will continue to comply with it, which is a requirement of Rule 31.55 of the DIC rules. So, my Lord, for all those reasons, we say that this expert report doesn't satisfy the rules, doesn't satisfy the necessary duty of independence, and is a great example of the expert assuming the role of an advocate.
Yes. Well, thank you very much.
We would invite the court not to scrap the application.
Mr. Kodeth,
Yes,
I'd like to hear you in reply now, please.
Yeah. Yes, Your Lordship. Your Lordship.
Yes, I'm just got to come out of the. Yeah. Just got to miniaturize the expert's report.
Yeah.
Just wait a moment.
Lordship, yeah.
Yes. Carry on.
So let me ask you, Your Lordship, whether we need to argue the merit of the expert report, whether we are arguing the merit of the expert report now, or
I want you to respond to the whole of the objections that Mr. Tolley has made.
Yes, sir. Let me say this expert has been appointed, has been hired by us as advised by small claim tribunal. So we hired the expert from the open market. We have no nexus with the expert previously. We hired him from an open market. He's a specialized engineer as well as a consultant engineer specialized in this field. So there is nothing wrong in accepting his report, Your Lordship. And let me say one more thing, Your Honor. I do admit that there was a delay from our part in filing this witness list. We do admit, because as per the order of the case management order of Deputy Registrar, which was on 3rd of September, CMO ordered that defendant has to file the witness list anything by 27/1 of 2021. We filed it was on 17/2 of 2021. There was a delay of only 20 days from our part in filing. That we do admit, Your Lordship. And I have filed the application with a prayer for a condemnation for the delay also.
Yes.
Yeah. And so, Your Lordship, may please to see condone the delay in filing the application, which is my request. And in addition to that, Your Lordship, may pleased to see that this expert report we have uploaded we have filed with the Deputy Registrar with the DFC code on 24th of August itself, much prior to this CMO order.
What was it? The
24th of August. 24th of August.
Yes.
Yeah, August. We have filed the report, expert report. We are uploaded in the system.
Yes, thank you.
Yeah, and this was taken place. This was taken place on. This order came thereafter on 3rd of September.
Yes.
Yeah. So it was, so what, I request Your Lordship, this expert report may be taken as a piece of evidence from our case to prove our case that claimant was failed to deliver the work as per the scope of work mentioned in the consultancy agreement, which is absolutely required to us to help us to prove that this claimant was terribly failed to deliver the goods what we required. It is report as not as per the specification in the scope of work mentioned in the consultancy agreement.
Yes. Now, you accept that the registrar made it clear that you would have to file a Part 23 application for leave to serve the expert evidence out of time.
Yes, Your Lordship.
Now,
I do admit. There was a delay from our part, 20 days delay from our part in filing this witness list.
Have you ever filed a Part 23 application?
It was by oversight. I have not noticed. By oversight, it was only a technical error, flaw from my part. We do admit. I have not noticed. By oversight, I have not noticed, Your Lordship. It is a technical error from our part, because this is the first time I have been appearing before this DFC court, Your Lordship.
Yes.
I am leaving the matter to Your Lordship to decide on that point.
Yes. Yes.
But still we submitted our expert report much before the order of the court, much before the order of the Deputy Registrar in case management order dated 3/9/2020. We filed the same report in 24th of August as a documentary evidence to support my case.
Yes, I understand.
Yeah. What I am requesting, what I am submitting before the Lordship, that the expert report may be accepted as an evidence from our part, documentary evidence from our part.
Yes, I understand.
Yes, Your Lordship.
Do you have any other submissions on in support of your application that the expert evidence should be allowed? You've covered a certain amount of ground. Is there anything else you wish to say on that? Because
it is absolutely required, Your Lordship. Because as per we hired an expert from the open market as advised by Small Claim Tribunal Court, Your Lordship, just to assist the courts to adjudicate the matter. Unfortunately, Small Claim Tribunal was not able to arrive at a conclusion, so matter was referred to Court of First Instance.
Yes.
So we hired accordingly.
Yes.
And which is very relevant to prove our case.
Yes, I see.
Yeah.
Thank you.
Yes, Your Lordship. Yes, Your Lordship.
Mr. Tolley, do you have anything to say by way of response?
No, nothing in reply, my Lord.
Now, I want to go on. We have an outstanding matter as to the trial date and so on, but I think what I'm going to do is I'm going to give judgment on the application to admit this expert evidence, and we will then consider the trial date and what the new timetable should be. Alia, are these proceedings being recorded?
Yes, Sir Richard.
Good, because I shall give an extempore judgment, which may need a little tidying up, and then the judgment should be filed in the normal way. And so I'm now going to give judgment. This is an adjourned hearing of a PTR. It arises out of the situation that had developed in this litigation concerning the evidence that would be called by the defendant. The defendant was subject to a deadline of the 27th of January to specify the evidence that it proposed to call. That date was missed. And upon the PTR, which was fixed for the 17th of February 2021, coming on, the defendant, through its legal advisor, Mr. Kodeth, applied for a retrospective permission to serve and file his witness list. And the names on that witness list were a Mr. Ahmed Ghali, who was to be an expert witness, and a Mr. Manoj Madhavan, who was an engineer in the employ of the defendant. At the hearing of the PTR, Mr. Kodeth made it clear to the court that he was not going to call lay evidence to be provided by Mr. Manoj Madhavan. He was in effect clearing that problem out of the way so that concentration could be focused on the defendant's desire to adduce the expert evidence of Mr. Ahmed Ghali. Or perhaps I should say, give him his full title. I think he's Dr. Ahmed Ghali. It's common ground that the registrar made it plain that a Part 23 application would have to be made for permission to serve evidence that was notified late and in breach of the earlier direction of the court. Mr. Kodeth did not comply with the clear direction of the registrar that a Part 23 application be made. This was notwithstanding that a communication was sent by the registry to the defendant, to Mr. Kodeth, giving some indication of what was required by way of a Part 23 application. The claimant filed an opposition by email to the application that was made, not a Part 23 application, but if I can call it an ordinary application, to have for permission to serve the expert report, and indeed any lay evidence that might be sought to be brought in, notwithstanding the clear representation made to the court on the 17th of February that no lay evidence was going to be adduced. Now, At the first of this adjourned, the first hearing of this adjourned matter, I indicated that I was going to refuse permission for the lay evidence proposed to be given by Mr. Manoj Madhavan should not be permitted. Now, my reasons for that decision are these. First, there had been a breach of the direction which required the specification of the witnesses by the 27th of January. Secondly, in the face of the court was told that lay evidence would not now be sought to be given. In my judgment, the defendant cannot be allowed to blow hot and cold on the question of lay evidence. The representation, which was intended by the court to be relied upon, and no doubt with the intention that it would improve the defendant's position on the expert evidence application, was made in clear terms and was accepted and relied upon by the court and by the claimant. What has happened here is that because the application has now come back before the court, in this instance before the court of first instance, the opportunity has been taken to make another attempt to call the lay evidence. I do not regard that as at all satisfactory. The proper thing to do by the defendant was to abide by the clear representation that had been made before the court on the 17th of February. And for that reason, the attempt to apply to the court before myself for permission to call the lay evidence is refused. Now I turn to the question of the proposed expert evidence. There is no doubt that there has been a delay and there has been a failure to comply with deadlines. However, my decision in respect of this part of the application is not essentially founded on these procedural breaches. My decision is founded on the substance of the report. This report does not identify a field of expertise which the proposed expert has, and nor does it contain views and opinions of and founded on the expert's expertise. This report strikes me as being essentially a report designed to achieve some sort of mediation. It's a report that argues the meaning of the contract. It is essentially an exercise in advocacy. There is virtually nothing said about how consultancy contracts of the sort we are concerned with are operated and used in the engineering field. Almost all of what Dr. Ahmed Ghali says can be made by an advocate and could still be made by Mr. Kodeth or whoever appears at the trial. I note that nowhere in the report is there an acceptance of the duty that an expert has to the court. This is an important part of an expert's report. The rules are quite clear. In RDC 31.6, it's made plain that the expert must not assume the role of an advocate. And in RDC 31.5, the expert's field of expertise has to be specified. This requirement has not been sufficiently fulfilled, and as I've said, the expertise which Dr. Ahmed Ghali has is not deployed in his report. He is not giving the court the background in the engineering industry in which these consultant agreements operate. And for these reasons, I refuse the application for the admission of this report into the Now, we must now turn to the trial timetable. I have consulted the registry, and I did consult the parties about possible trial dates. And this trial will take place on the 12th of May, with the possibility of it going over into the 13th of May. Because of time differences, and in the light of the fact that the trial will be a virtual proceeding, the duration of the hearings is bound to be truncated. We will not have a full working day as we would have if this were an in-person hearing. And it is for that reason that the trial will be listed for the 2 days. It may be that the trial can be successfully completed on the 12th, but if there is, if that is not achieved, we'll have the 13th as a fallback to complete the proceedings. Now, the outstanding timetabling matters are the following: the trial bundle, the reading list and the trial timetable, the skeleton arguments, an agreed chronology, and then the trial on the 12th of May. I've had a look at the original timetable, and the period of time between trial bundle and trial was about 2 weeks. And what I propose, although I am happy to receive submissions, is the following: that the trial bundle be served on the 28th of April, that the reading list and final timetable be served on the 2nd of May, the claimant's skeleton argument on the 5th of May, the defendant's skeleton argument on the 6th of May, and the agreed chronology on the 9th of May, then the trial coming on the 12th. Mr. Kodeth, do you have any representations you'd like to make about this proposed timetable?
That is okay. That is okay for me, Your Lordship.
Thank you very much.
I have no objection, Your Lordship.
Yes. Mr. Tolley?
No, nothing from the claimant, my lord.
Right. Well, I would like an order drawn up. And I do urge the legal representatives of both sides to cooperate in the drawing up of the order. It's not a complicated order. The applications to adduce lay evidence and expert evidence is refused. The new timetable and trial date is specified. And we then come to the question of the cost of the application. Do you have any submissions, Mr. Tolley?
My lord, my hesitation is because this is a pro bono matter, and I think in those circumstances costs aren't recoverable in the ordinary fashion. My understanding is that it is possible for the court to make a costs order that's adverse to the party that's said to have wasted costs in some way, but that results in some sort of, I hesitate to say charitable donation, but donation to the court fund. My colleague Amin is on the call, I think. Amin, do you recall the title of the cost section that's applicable to pro bono applications? Are you there? If not, my lord, the claimants are not minded to pursue any cost application.
No. Well, Mr. Kodeth, I'm not going to make an order for costs in respect of your failed your failed application, and that I think concludes this matter.
I'm much obliged, Your Lordship.
And so we shall meet again. I shall be the trial judge, and we shall meet again on the 12th of May.
Yes, my lord.
Thank you both very much.
Thank you. Have a good day. Bye-bye.
Thank you, Your Lordship. Thank you, Your Lordship.
Bye-bye.
Bye-bye, Good Lord.